Welcome back, Attorney Steve Vondra, and welcome to another exciting video. Okay, so we are talking in this video about torrents. Specifically, we are talking about the United States Court of Appeals case from the Ninth Circuit, the Cobbler, Nevada case. Now, this is a good case. Again, we had a great case in D.C. We've had a couple good cases up in San Francisco. We have good case here from the Ninth Circuit Court of Appeals. And this is the Cobbler, Nevada LLC versus Thomas Gonzalez case. Okay, so this is important to know. So when a case goes up on appeal, as this will say, for publication, do you see that? It says, let's get it over there, for publication. That means you can cite it in a court of law. A lot of times good case law will say not for publication, okay? But this says for publication. So that means it's case law that you can cite in the Ninth Circuit, which is, kind of the western part of the United States, California, Arizona, Oregon, Washington, Idaho, Utah, Nevada. Okay, so this is a case basically that deals with, and I'm going to read you just a couple parts from the case, but let's see if I can go here. So essentially the case deals with these torrent companies that accuse you of illegal file sharing. Our firm represents a lot of people that are accused of illegal file sharing, software, games, videos, films, those kinds of things. And normally they file these John Doe lawsuits that basically are just tied into an IP address. They just say, we are suing 25.25.88.100, the IP address. So they're suing the IP address because that's what they're monitoring. They're in the torrents. We had a great video by Lights, Camera, and Action. He did a video about how you get caught torrenting, and you can see that they're tracking IP addresses when they're watching these files being shared on the swarm, as they call it, the swarm. And so in this case, the defendant worked for a foster care home, and he was the manager, as I understand it. And he basically, just like every torrent case, they name the IP address and they serve a subpoena on the ISP, your internet service provider like Comcast or Cox, and they want to get your information. They want to find out your name and your address. So in this complaint, they allege that the IP address was the infringer, and that's really all they alleged, and some other things that we'll go into here. But the court said that's not enough. That's not enough. Just you got to have something more, because a subscriber, like the subscriber at a foster care home, there's a lot of people in there with laptops and computers that could be hooked up to the Wi-Fi network, cell phones, okay? And so the court said, just alleging that, that Thomas Gonzalez is the guy, it wasn't enough. So let's go through and take just a quick looks here. It says, after tracing infringements of its copyrights to a particular IP address, Cobbler, Nevada LLC filed suit against the John Doe IP address for direct and contributory copyright infringement. Now, those are two different claims. Direct infringement means you did it. Contributory infringement means you helped someone else do it. So they're saying, if you didn't do it, Mr. Gonzalez, it would have been someone else that you helped aid and abet. So that's the allegation, again, based on an IP address that they tracked. Cobbler, Nevada soon discovered that the IP address was registered to Thomas Gonzalez, who operated an adult foster care home. Cobbler, Nevada then amended its complaint to name Gonzalez as the sole defendant. So they amended the complaint, put Thomas Gonzalez on the complaint in the name of in place of one of the John Does, alleging that he directly infringed by copying and distributing copyrighted works himself, or in the alternative, contributed to another's infringement by failing to secure his internet connection. So this is the unsecure Wi-Fi defense, where you say, sorry, my Wi-Fi was unsecure. It could have been my neighbor in a camouflage suit and pant and shirt sitting out by the bushes. So I don't know. It was unsecured Wi-Fi. So we get that a lot. So the district court that heard this case dismissed Cobbler, Nevada's claims. The direct infringement claim fails because Gonzalez's status as the registered subscriber of an infringing IP address standing alone fails, because this does not create a reasonable inference that he is also the infringer. So that's the key. So what the court's saying is, and the appellate court here agreed with the district court in affirming the decision. So what they're saying is, and I'll just go into it a little bit further here, because multiple devices and individuals may be able to connect via an IP address, simply identifying the IP subscriber solves only part of the puzzle. A plaintiff must allege something more. The plaintiff must allege something more to create a reasonable inference that a subscriber is also an infringer. So there you have it. That's like the golden language. That's like butter in your ear. You go putting a higher standard on these parties that file these kinds of complaints. And, two of the main ones we deal with are Strike 3 Holdings and Malibu Media. These are adult videos and films that are copyrighted, that are shared on the internet. And of course, they want huge amounts of money to get these cases settled. So it says you must allege something more. So simply saying, hey, they're the subscriber, like maybe I'm the subscriber here, but there's other people that can log on. Just because I'm the subscriber doesn't make me, sue worthy. So that's what they're saying here. So this is really good language coming out of an appellate court that you can actually cite in a case as at the minimum persuasive authority. Nevertheless, Cobbler, Nevada filed a first amended complaint and named Gonzalez as the sole defendant. The only facts in support of the Cobbler, Nevada's direct infringement claims were that Gonzalez was the subscriber of the IP address used to download or distribute the movie, and that he was sent notices of infringing activity to which he did not respond. So he got some notices, and they're saying, well, you didn't respond, so that must be you. Courts saying that's not enough. That's not enough, okay? Relying on the magistrate judge's reasoning that these allegations were not enough to state a claim. See? Not enough to state a claim because there were no facts, folks, connecting Gonzalez to the infringing activity. The district court dismissed the district infringement claim without prejudice. Okay? So in this case, the court, that's how the case started out. But then it went to, and I'm going to post this case online on my blog, attorneysteve.com, if you want to check that out, attorneysteve.com. So a little bit further here, though. So the court talked about the direct infringement claim. That's when you say, I have evidence that you infringed. Court says the only connection between Gonzalez and the infringement was that he was the registered internet subscriber and that he was sent infringement notices. To establish a claim of copyright infringement, Cobbler, Nevada must show that it owns the copyright and the defendant himself violated one or more of the plaintiff's exclusive rights under the Copyright Act. So you have to make these allegations in your complaint for your complaint to be sufficient. So you need to outline how did Gonzalez copy or distribute. You have to make that allegation is what this court is saying, at least to me. Now, lawyers can differ on their interpretations of things. We know Attorney Steve is always right. But anyway, so let's go. And this says this is a situation where a complaint pleads facts that are merely consistent with the defendant's liability, stopping short of the line between possibility and plausibility of entitlement to relief. The allegations are not enough to raise a right to relief above a speculative level. Okay, so it has to be a little more than speculation, more than just, hey, this is the IP subscriber. So this is very valuable language. If you end up in a litigation, you might be able to use this. Okay, also you might be able to use this in a motion to quash a subpoena, arguing that the complaint is invalid. Why are we even going to the subpoena stage? So we'll have a case. I'll be briefing on that. Make sure you subscribe to this channel to make sure you get these updates that are coming out. I don't know too many other lawyers that are putting out great nuggets like this, helping you understand the law in this area so you don't get railroaded like a lot of people call me and say, is this a scam? What, is this real? Yeah, it's real. So contributory infringement, very simple. The plaintiff's allegation was that the defendant failed to police the foster care home and see who was doing what. Court says this is not a sufficient linking Gonzalez to the alleged infringement. So you can't try to put some duty on somebody to police, according to this case and the facts of this case. The contributory infringement claim, the court said, liability exists if the defendant engages in personal conduct that encourages or assists the infringement and plaintiff simply had no facts to show that Gonzalez encouraged, assisted, aided, abetted, any of that kind of stuff, okay? So at the end of the day, Gonzalez, in a nice turnabout, in a nice roundabout, was seeking his attorney fees. It looked like the court granted it. I don't know what the attorney fees were, but it looks like that sends a big signal to these internet companies, to these movie companies, production companies that are sharing their movies on the internet. And you know, some people question, are they seeding the torrents on their own? Or I said, look, I don't know. If you ever find any evidence, that if you know of any evidence where these companies are uploading these videos on their own to get it into the torrents, you know, please call our office. You can find us at attorneysteve.com, because, you know, that's something. There were 2 lawyers that were actually disbarred because they bought copyrights and started putting them up on the internet through these shell companies. So, you know, that kind of stuff, that's valuable if we can get that information. But I just thought you'd like to know, again, you know, it's, you know, case law, sometimes it's like pushing that big wheel up the mountain top, like Sisyphus. Remember him, Sisyphus? Pushing that big rock up the mountain. It takes a while to get it going, but we have some good case law coming out of different jurisdictions. You know, maybe a little momentum going here. So this is really good, but this puts a higher standard, in my opinion. This is not legal advice. This is general legal information only, but in my opinion, puts a little bigger burden on them to plead those facts. If you don't have those facts, you know, it could be subject to a motion to dismiss or a motion to quash, or basically, you know, basically challenging their pleading, okay, on a motion to dismiss. Okay, so that's basically it. Cobbler, Nevada. Look it up. I'm going to put it on my blog. So if you want to find out more information about it, read all the detailed language. But I already gave you the best. You don't have to skip around forever. I already gave you the good stuff. So attorneysteve.com. Have a great evening. I got to get running. Still got lots to do tonight, but we'll be back. Hope you enjoyed this video. Like, subscribe, comments. We'll see you again.